Good afternoon. Welcome, students and faculty and alumni and friends, to the University of Minnesota Law School's inaugural Charles Rubenstein Lecture. Judges, come in. Welcome. I am William McGeverin, Dean of the Law School. It's wonderful to see all of you here today. This lecture series was established by Mr. Charles Rubenstein, class of 1955, a longtime friend and supporter of the law school. At the time of his passing in 2021, Mr. Rubenstein was one of the law school's oldest living alumni. I think we weren't sure. He might have been the oldest. We were not positive. He was age 99. He was born into a family of Russian Jewish immigrants. He served in the U.S. Army during World War II. After graduating from Minnesota law, he practiced as a sole practitioner in many different areas of the law. Through his estate, Mr. Rubenstein made significant gifts to two of our scholarship funds that are going to help fund multiple students to receive their Minnesota law education each year: the Judge Harry H. McLaughlin Memorial Scholarship Fund and the C. Blaine Harstad Scholarship Fund, both of which honor longtime friends and classmates of Mr. Rubenstein's. And he also created his lecture series to highlight the impact of Jewish contributions to the U.S. legal system. Thank you to Chuck Rubenstein and his family for these thoughtful contributions. We are so grateful for this support. Now, today, we are honored to have our special guest, Professor Noah Feldman. Professor Feldman will speak on the pervasive method, Jews in American legal education, an important and very timely topic. Noah Feldman is the Felix Frankfurter Professor of Law, Chair of the Society of Fellows, and founding director of the Julis Rabinowitz Program in Jewish and Israeli Law at Harvard University. He specializes in constitutional studies, particularly those that emphasize power and ethics, the design of innovative government solutions, law and religion, and the history of legal ideas. Professor Feldman is a policy and public affairs columnist for Bloomberg Opinion, the New York Review of Books, and the New York Times Magazine, which I've heard called the Holy Trinity of Punditry. He has been a contributing writer for nearly a decade, and he also hosts the Deep Background podcast, a really riveting interview show that explores the historical, scientific, legal, and cultural context behind big news stories. He's the author of 10 books, including his latest, To Be a Jew Today, A New Guide to God, Israel, and the Jewish People, which was published last year. Welcome back to Minnesota Law, Professor Feldman. We are honored to have you here today. Come up, Noah. I'm going to do two logistical notes real quick before we begin. Today's event is being recorded. I'm a privacy law professor, so I always have to say that. Today's event is being recorded. Following the lecture, I hope people will join us upstairs in our back commons for light refreshments, right? On the way to the main door, it will be where the people are. And now, let's all welcome Professor Noah Feldman with a big round of applause.
Thank you so much, and thank you all very much for having me here. This is the second time I've had the opportunity to speak at this law school. The last time was 25 years ago when I was not even a baby professor. I was a baby wannabe professor, and I came for an interview here. And I would say the two big differences between that talk and this one are that I didn't have any gray hair at the time, and I'm less nervous this time. So that's the big shift. Topic, however, interestingly, is not so far afield. At the time, I was talking about religious liberty and the origins of the Establishment Clause. So I was talking about the relationship between the law and religion and the constitutional groupings and identities. And today, too, I'm going to be touching on those questions, but there will be very little doctrine in today's talk. So for those of you who came looking for constitutional law doctrine, you'll have to quiz me in the Q&A, and you're free to do so. And for those of you for whom that's a relief to hear a talk in a law school that isn't all about legal doctrine, you're welcome. So I want to talk today about a puzzle. And first, I'm just going to describe the puzzle and then I'll dig into it. And the puzzle is this. There are at present, although it may not always be the case, and have been for roughly the last 75 or 80 years, a very large number of people of Jewish origin in American legal education. To put it bluntly, lots of Jewish law professors. When I was making my notes for the talk, I wrote down so many Jewish law professors. And I'll give you a few statistics to suggest that that's the case and how it evolved in a moment or two. But first, I want to tell you what the puzzle is. The puzzle is there anything distinctively Jewish about the way that those folks do their jobs? And if so, is there anything distinctively Jewish in the influence that Jewish law professors as a whole have had on the American system of legal thought? And the reason it's a puzzle is I want to start by giving you some examples of pretty obvious cases where there might be Jews doing something, but there's nothing Jewish about the thing they're doing. So let me start with the easiest example. In 1972, when I was 2 years old, Mark Spitz won 7 gold medals in swimming at the Munich Olympics. For younger people, he was Michael Phelps before there was Michael Phelps. And Spitz was Jewish, is Jewish. And as far as I can make out, there is absolutely nothing Jewish about the way he swam at the Olympics. Right? I mean, even if you told me, and I looked at some biographies of him to see if this is true, and I think it isn't true, but even if you told me, counter to fact, that he said, well, the reason I swam that hard is I was trying to prove, that there could be a Jewish gold medalist, and I did it so well, I did it 7 times. That still wouldn't qualify, from my point of view, as showing that there was anything Jewish about what he was doing. Maybe there was something Jewish about the motive. A slightly more high-profile example would be Einsteinian relativity. Now, we know that the Nazis said that the theory of relativity was, quote, Jewish physics. And it turns out that it's really lucky they thought that, because that made it impossible to teach the theory of relativity at German universities in a relevant period of time, which contributed to Germany failing to get the atom bomb when the United States, aided by many, many Jewish emigre scientists from Europe, did get it. So thank goodness they thought that. But the idea that there could be something Jewish about a theory of the natural universe that is demonstrated by a combination of rigorous mathematical analysis and empirical experimentation also seems to me to be obviously wrong. Obviously wrong. So those are easy cases. Then there are genuinely tricky cases. What about psychoanalysis? Right? Psychoanalysis does not present itself as in any way Jewish. And Freud was at great pains, again, to deny that there was anything Jewish about his theory. His one-time friend and later intellectual antagonist, Carl Jung, did think there was something Jewish about Freud's version of psychoanalysis, but he didn't think that psychoanalysis itself was Jewish because he had his own version that was very much au contraire, as they say. So was there something Jewish about psychoanalytic thought? The argument on the positive side in the affirmative relies on a pretty subtle kind of cultural argument about myth-making and archetypes. And I'm not going to talk about this today, although I'm happy to talk about it in questions and answers if you like. I would say my conclusion is sort of like the Scotch verdict, not proven. There might be something to it. You can make out a case for it, but it's also not definitively so. So my puzzle is to ask the same question about American legal thought as it has been expressed in the thinking of American Jewish law professors. And just to deepen the puzzle, almost without exception, almost without exception, there might be one or two exceptions, but almost without exception, the American Jewish law professors who have professed ideas about law in the United States would absolutely deny that there was anything Jewish about the content of their thinking or approach. And to deepen the puzzle even further, if one were to suggest, as you might on the surface, that, well, Judaism is bound up historically in the study of the Bible and the Mishnah and the Talmud, so collectively the written law and the oral law, and Judaism has a 2,000-year tradition of deep engagement with these texts, and there's a lot of law in these texts, and there's a distinctive style of study associated with these texts, and perhaps that style has had an influence on American Jewish law professors. You run into the problem that, again, with only a couple of exceptions, maybe half a dozen, there's been no major influential American Jewish law professor who actually had any direct significant training in those traditions beyond, say, a grade school level, which is itself a puzzle. Why is that the case? That's a sub-puzzle, but it's not the main puzzle here. So in other words, even if we thought there were some influence, it can't be, as it was, for example, in certain fields in the late 19th and early 20th century, when Jews in Eastern Europe suddenly had the opportunity to attend universities which had been closed to Jews for centuries. And by the time they came to university, they were people who had studied in traditional Talmudical academies, yeshivas, and they arrived at 18 or 20 or 21, pretty deeply steeped in those traditions, and then they were let loose on whatever else it was they were studying. And in some instances, I think you probably can show that direct influence. You can't make that argument for the American Jewish Legal Academy. Okay, so that's the puzzle. I owe you, I think, one word of empirical support for the idea that there are a lot of Jews in the American Legal Academy, and maybe a word or two of explanation about my title, which is based on a joke that I heard once that made a big impression on me. Unfortunately, I'll have to explain the joke, and as we all know, if you explain a joke, it's not funny. So it won't be funny, but it will at least be suggestive. So let me start with the empirics. When Felix Frankfurter, for whom my professorship is named, became a law professor at Harvard assistant professor just after World War I, the 1920s, he was the first person of Jewish origin to serve on the Harvard Law School faculty. And there was even some controversy about that at the time. From the first time there was a dean of the Harvard Law School, and around 1870, Christopher Columbus Langdell, for the next century, Harvard Law School had 7 deans. I just looked this up today. And of those, none was Jewish. From 1971 until the present, Harvard Law School has had 6 deans, of whom 5 were Jewish. That gives you some general picture. Now, to become dean of a law school, you typically have to have been teaching at that law school for some period of time. There have been some historical rare exceptions. Person who went on to become president of the University of Chicago became the dean of the Yale Law School when he was 27 years old in the 1930s. That's a strange and bizarre outlier with its own fascinating story to it. Ordinarily, you have to have been teaching for a while. And so if Jews began to become law school deans in the early 1970s, and I noticed that we're having our event, our reception, I think, in the Auerbach Commons, named, I think, for Dean Auerbach of this law school, who I looked it up, and he became dean of this law school also right around 1970. So if that started happening in that period of time, you have to figure it was really and this turns out to be statistically true, it's really in the 1950s that you began to get significant numbers of Jewish law professors entering the legal academy, really at scale. So that's to give you some sense of the historical trajectory and timing of how this happened. I'm happy to talk more in detail if people are interested in the historical process. But that's basically the timing and the scale. And I want to quickly note, there is reason to think that, that this phenomenon has statistically peaked. Strong reason to think that it's peaked. A glance by me at my own law schools, just sort of top of the line glance at how many Jewish professors at different points in time, and a handful of other law schools suggests that the peak probably was somewhere 15 or 20 years ago, when there were still a lot of young Jewish law professors being hired, and there were lots of well-established Jewish law professors who were reaching retirement. Since then, I think there's been a meaningful decline in the number of Jewish law professors at those schools, also for reasons that I think have nothing whatsoever to do with anti-Semitism and everything to do with the broadening of legal academia to a broader array of people with different kinds of backgrounds, and perhaps also to the further you are from immigration, the harder it is to incentivize your children to work extremely hard at any one thing. And in general, I know this is always the case, to become a law professor, you have to be willing to work very, very hard at a bunch of things for a long time. I don't mean to say that once you are a law professor, you always have to continue to work that hard. I think the theory of tenure is basically that if you wind people up like a toy, you wind them up and they walk very steadily and hard, and you give them tenure, they'll probably just keep on walking, as opposed to eventually, collapsing. So if you brought up to work very hard, you'll probably keep working very hard, even when you have tenure, and in theory, you don't have to. At least that's my excuse for still working very hard every day. So I think that was probably the peak, and I think it's declining. So whatever else I'm going to say, none of this is necessary. None of this is inherent to the structure of the United States or of the legal academy or any of it. We're talking about a trend that was meaningful for a meaningful period of time. If we start our numbers in, say, 1950, I'd imagine a peak coming perhaps roughly around 2000. We're talking about, and there's a rise and a climax and a slow, not a rapid, but a slow decline. We're talking about what may in the long run be truly a 50-year phenomenon, although if you extend it back to Frankfurter and forward into the future, you could get it up to a century, I think, if you wanted to. Okay, so here's the joke. And I need to give you background for the joke, which is another piece of evidence it's not going to be a funny joke when I tell it to you. So when I was a student, I went to the Yale Law School, and when I was a student there, Yale did not teach a separate course in legal ethics or the legal profession. Instead, they relied on a somewhat known, but not very well known, loophole in the American Bar Association's requirements for how law schools could teach you legal ethics. And the ABA official report said you can either teach a legal profession class to fulfill the ethics requirement, or you can teach it by what the ABA called the pervasive method. And the pervasive method is the idea that embedded in a whole range of courses will be the kinds of questions that are supposed to develop your faculties of ethics within the legal profession, and that satisfies the ABA requirement. And so that was how Yale Law School taught legal ethics by, quote, the pervasive method. Yale wasn't the only place that did it. Notre Dame did it that way too. There may be a few schools that still do it that way. But in any case, that's the context for this. The other piece of context is when I was a student at the Yale Law School in the 1990s, there were a lot of Jewish professors. My fall 1L lineup had 3 out of 4 Jewish professors in my mandatory classes, and that was not in any way, shape, or form uncharacteristic. No one walked around counting, but the law faculty at Yale at the time had to be at least 60% Jewish. Had to be. At the same time, since the untimely passing of the late and very great Professor Robert Cover, who was one of the very, very few professors in the American Legal Academy who wrote specifically about Jewish law and tried to take Jewish law ideas, Talmudic and biblical ideas, and bring them to bear on American constitutional law. He did that very, very famously in an article, a foreword for the Harvard Law Review's annual Supreme Court issue called Nomos and Narrow, a kind of classic article for this intersection. After the time that he passed away, and he was very young when he died, no one at Yale took any interest in teaching Jewish law in any way, shape, or form. And indeed, when a charitable foundation, the Gruss Foundation, came around to a number of law schools earlier than that, in the late 60s and early 70s, and offered them endowed visiting professorships in Jewish law, Yale did get one. I think they turned it down. It's what, in fact, happened. So someone once asked at a Yale faculty meeting, why don't we have anybody teaching Jewish law here? And Bruce Ackerman, was part of the joke too, who was a professor at Yale Law School at the time, constitutional law professor, witty, funny, immediately without a break responded, "We teach Jewish law by the pervasive method." Now, the reason I'm glad I got some laughs, 'cause then I can explain why that's funny. Part of the reason that it's funny is the surface level. But part of it was that Ackerman himself, fascinatingly, he was my teacher, I have an enormous amount of respect for him. He's one of those unusual people who, though born to a Jewish family and in cultural style about as Jewish seeming as a human being could seem, I've heard him say in public, he doesn't think of himself as a Jew. And more power to him, that's his right and authority. But it was particularly interesting that he was taking that position here, because what he means when he says that is surely, at least in part, that he thinks that being Jewish, ethnically or by heritage, plays no role whatsoever in his thought world. It must be that he thinks something like that. I think that he thinks something like that. And so it's especially funny that he, of all people, was saying in a room full of people, many of whom were Jewish, that they were using the pervasive method because it would have to be a method of unconscious transmission without any real effort to do it, which is also how I think a lot of us thought about their legal professions curriculum at the time, which was supposed to be by the pervasive method. But what I think that meant was we didn't really know anything about legal profession, and we really didn't know anything about what legal ethics were actually meant to look like. We just knew there was something called ethics generally, and maybe this was some special case. So I chose that as my title because I think it captures something about this puzzle. What would it mean even to say that there was something Jewish about legal education or American legal thought through the lens of all of these Jewish professors? And so I thought this was especially appropriate because the topic for this lecture, as set by the Charles Rubenstein lecture bequest, was about the influence of Jews in the American legal profession. And so I thought, instead of just asking, can we make a list of Jews and say they were influential in the American legal profession? The answer is yes, we can definitely do that. We can do a lot of that. You know, it's easy to drop the names. It would be more interesting to ask, well, given that there were people who were Jewish who contributed to the American legal profession, was there anything Jewish about the thing they contributed? And that's the puzzle that I'm interested in. Okay, so how would we even go about answering that question? The question that I'm asking isn't an question that you can answer with statistics and empirics. I started with a few suggestive statistics just to get the hypothesis on board that there are a bunch of Jews in the American legal profession, and have been. But just pointing out the numbers would not answer the question that I'm asking, because the question I'm asking is not quantitative, it's qualitative. It's about the whatness and the howness of how ideas reflect a certain set of values or ideas or cultures. So the first thing we have to recognize is this is a question of qualitative analysis. Second, in a perfect world, I would love to say, because I get to use a very fancy word, that this is some phenomenological analysis, that this is an analysis of what it feels like experientially to be embedded in the phenomenon of legal teaching and legal study and legal theory. But even though I was really excited about that formulation when I was writing up my notes, I ended up dissatisfied with it. And I ended up dissatisfied with it for a very specific reason, which I hope will be a bit of a clue on our way to solving our puzzle. And that is, a phenomenological account starts by asking people, what does it feel like to you? You can even ask yourself, what does it feel like to you? And if you ask the people that I'm talking about, Richard Posner, or Ronald Dworkin, or Larry Tribe, does it feel Jewish to do your job? 100% guarantee that all of them would say no. So vociferously that in the case of Ronnie Dworkin, whom I was lucky enough to be a little baby professor when he was a very senior professor at NYU, I would have been terrified to ask him that question. So vociferously would he have looked at me, he was a very kind person. He wouldn't have said anything, he just would have looked at me as if to say, that was an incredibly inappropriate question. Because he would have said, no, not in any way, shape, or form. And if you ask them about that generation of professors, about their mentors, You would hear from Dworkin about learned hand. You know, you would hear from Posner about Holmes. It wasn't his mentor, but his model. Holmes can be all things to everyone, which is how Holmes could be the model for Posner and also for lots of very un-Posnerian people. So the phenomenology approach, I don't think it's going to get us there because I don't think it would produce any kind of meaningful answer. But it does include a clue. And the clue that I hit upon while thinking about how phenomenology was the wrong way to answer this question, the clue was, forgive me, I'm just going to get some water. The clue was that precisely there would have been a denial or a disavowal of Jewishness by these law professors. Not in the extreme form, the Bruce Ackerman form of disavowal or denial of being Jewish at all, but in the more modest form, and definitely defensible form of saying, there's just no overlap here. It's just a coincidence. Sometimes when people tell you very vociferously that something has no impact whatsoever on their job or their lives, if their affect, their tone, their intensity is strong enough, we all have the same intuition, which is to say, you know, methinks thou doth protest too much. There might be something hiding behind that. So that's the first clue I'm going to give you as I try to work my way towards a working theory here. That the vociferousness of the denial, which I'm going to call a disavowal, may be a piece of the story. So now let me finish by saying what form of analysis I'm using now. It's not quantitative, it is qualitative. It's not really phenomenological because I ask people what they feel like, and at least in my hypothetical, almost all of them are going to tell me, I don't feel like that at all. So then what am I doing when I say, yeah, that's really nice, but now I'm going to try to get behind that? Well, what I'm doing is basically a form of analysis, and it's a form of analysis that you might call, if you're really nasty, you'd call it the hermeneutic of suspicion. You know, I don't trust you, but that's not exactly right either. It's not that I don't trust them. I just don't think that their conscious minds are responsive to my question. I didn't ask the right question. It's a little bit more like a form of cultural analysis in which people's theory of why they're doing what they're doing isn't enough to fully explain it. And in a very, call it psychologically sensitive form of cultural analysis, we want to know not only what do people think they're doing, but what might really be driving them. And therefore, we're willing sometimes to accept answers that the person himself or herself wouldn't ultimately accept either. Now, most of the time, I tell, let's say they're doctoral students and they want to research some problem and they say they want to go interview judges. Let's say they're doing a statistical study of quote unquote ideological bias among judges. First of all, I tell them I don't supervise those kinds of theses, but if there's some members of the bench in the room, you'll know there's always someone showing up and trying to do something like that. And first they go and interview the judges, and the judges always say the same thing, which is sincere, which is, you're out of your mind. This is not how we do our job. And then they'll back it up with statistics. My court, we agree 95% of the time, 98% of the time sometimes. There's just a few outlying cases that are difficult that maybe have ideological content and component. And some of that never stops the graduate students who want to keep on and they want to count up cases and make an assignment. And the result is often cognitive dissonance for the judges. I had the privilege of serving as a law clerk to Harry Edwards, a former law professor at the University of Michigan and at Harvard, who then became a judge on the DC Circuit. And when I was clerking for him on the DC Circuit, he was the chief judge. And to say that he was incandescent with rage when then professor, later dean, Ricky Revesz of NYU published an article about ideological bias in environmental cases decided at the DC Circuit is a substantial understatement. And from those of you who know Judge Edwards as I do and who love him as I do, you'll know that his incandescent rage is really scary. And I was his law clerk when this happened, so I heard a lot of this incandescent rage. And then he decided to write an article refuting that. And I was the law clerk assigned, well, a law clerk, to help him write that article. So I lived this for a substantial part of my clerkship experience. And it was one of the most fascinating exposures to cognitive dissonance you could imagine, because no matter what the statistics said, there was no way on earth that he could take it on board. No way on earth. As it happened, Revez's data set was pretty rigorous at the time. It was over like 40 years. And it was also fascinating because it did, as most of these studies do, it evaluated judges based on the political party of the president who had appointed them. And it lined everybody up in environmental cases, and it used, who was the plaintiff as a proxy. And of the, I think, 30 odd judges who were included in the study, all but one could be neatly arrayed in one of the two graphs. The only one who couldn't was an amazing judge, now passed away sadly, called Stephen Williams. And just to test the phenomenology account, I stopped him and I said to him, Judge, I have this study I want to show you, but can I just ask you a question? What do you think are your biases in the context of environmental law? He said, well, I used to teach environmental law when I was a professor at the University of Colorado. I said, I know, that's why I'm specifically interested. He said, well, why do you ask? And I said, well, because there's this longitudinal study and you're the only judge in the DC circuit, basically since there was environmental law, who's right in the middle. And he said, oh my God, I'm shocked by that. I thought I was extremely conservative, which showed me that the cognitive bias was total. But even the one person who had, I don't know whether he didn't have bias, but he was right down the middle, he thought he did have a particular perspective. Okay, so that's the kind of question I'm asking, and it can drive a person crazy if they're the person who's being accused of harboring a bias and they say, but I don't hold that bias. So take that in the spirit in which it's offered of honesty. So what might be the Jewishness behind the denial of Jewishness? Well, I want to start answering that with the phenomenon of why judges might want to say there's nothing Jewish about, a judge might want to say there's nothing ideological about my judging, and why a professor might want to say there's nothing Jewish about how I do my job. Well, the first reason to want to deny it might just be that it seems inapposite, right? They might say, in my generation, there were lots of Jewish doctors, nothing particularly Jewish about how they did their medicine. Lots of, fill in the blank for other professions, lots of Jewish accountants, lots of Jewish dentists, but there's really no Jewish dentistry. And as I said earlier, that seems to be a view that I share too. That doesn't seem to make sense. So that might be one reason to say it's to dismiss the idea, but that wouldn't be a reason to dismiss it with frustration. I think the reason for the frustration then might be a fear that somehow they would be accused of somehow distorting the law in some way, or they might become subject to anti-Semitism. But most of the professors I'm talking about were living in a golden era of American Jewish life, where they might have experienced some anti-Semitism as kids, but as adults, they were occupying tenured positions in prestigious institutions, played important roles in the law, which is one of the most important sets of institutions in American political and institutional and economic life. I don't think that was the primary motive either. I think the motive has to do with something that Brandeis himself, Louis Brandeis, talked about. It was heavily influenced by Felix Frankfurter. These are the two, as it were, ideals of the American Jewish legal type for the generation that I'm talking about. They may not have directly known Frankfurter, although some did, and none of them directly knew Brandeis, but these were huge models to be held up. And that's the idea of what Brandeis and Frankfurter, in the jargon of their era, flatly called Americanism. And for Brandeis, that began early in his career with a clear public statement that he made many times, that he was against the idea of hyphenated Americans, which, believe it or not, had already been introduced in the early part of the 20th century. There was just one kind of person, to paraphrase Justice Scalia in his Adirond opinion, we are just one race here, it is American. So this was an ideology that took the view that to be an American was to shed any sense of identity, affiliation, and potentially allegiance to anything other than being an American. Now, Brandeis was not himself an immigrant. He was born in the United States, but his family, who had emigrated from Bohemia, his father suffered an economic reverse when he was a teenager, and he picked up the whole family and took them from Louisville, Kentucky, took them back to Germany, and as a consequence, Brandeis had to consciously decide to come back to the United States for university, and he went straight to Harvard Law School as part of that decision. In those days, you didn't have to go to college before going to law school. So for Brandeis, living in the early part of late 19th, early 20th century, this is the early Brandeis, there was a pretty strong and powerful idea that to be an American was not to be the other thing, a Jew. Now, with Brandeis, when he was 55, which is the age that I am, he woke up one day and was convinced to become a Zionist. And in that context, he developed the idea that it was possible to be both a loyal American and also eager to enable Jews to settle what was then Palestine. And he had to have an elaborate theoretical explanation for how this was possible, and he did. Specifically, it had to do with his own civic republicanism, his own Jeffersonian agrarian civic republicanism, which he then projected onto the early Zionist settlers. And so he thought that those settlers were going to realize the American ideal. And so that's a lecture for another day, and it's also usefully discussed in Jeff Rosen's terrific short biography of Brandeis. But bottom line, the early Brandeis, the one that influenced Frankfurter in this particular way, was very committed to this idea of Americanism. Frankfurter took it further. Frankfurter was an immigrant to the United States. He came when he was 12 from Austria, from Vienna in particular. And his family was religiously observant. And he remained religiously observant until he was a student at City College of New York. And one day he walked out of, in his sophomore year, he walked out of morning services and said, "I'm done." And that was the end of his Jewish practice. And except for some involvement with the Zionist cause that he was brought into by Brandeis, it was also the end of Frankfurter's involvement with the organized American Jewish community. Frankfurter took the view extremely powerfully, and he said it explicitly, "For me, my Americanism has replaced my Judaism." And he said that effectively, the Constitution was now, and the most famous place in which Frankfurter said this is one of the most poignant opinions that anyone has ever written in the whole of the US reports, which is Frankfurter's dissent in the Barnett case in 1943. Here, Frankfurter was dissenting. This is one of those opinions that you're not proud of, the generations are not proud of, though Frankfurter was proud of. He's dissenting from the opinion that holds that the Jehovah's Witnesses kids in school may not be compelled to salute the flag during the Pledge of Allegiance and recite the Pledge of Allegiance. So Frankfurter's dissenting. And he's dissenting because he had written the majority opinion just 2 years earlier, holding for the court that the state may compel the kids to salute the flag, notwithstanding their dual First Amendment objection, their free speech objection, which is what the court case was ultimately decided on, and their free exercise objection. And in this dissent, and Frankfurter was heartbroken by the way the court had flipped. It signaled many things in his career, including that this person who had been the most prominent law professor in the United States, the most prominent liberal professor in the United States before going on the court, was expected by one and all to become the leader of the court, was now losing leadership of the court because it was happening in front of him in real time. He had gotten a majority, now he was losing his majority just a couple years later. So he was very distraught, but he was particularly distraught because he felt that he had a good understanding of the value of a holding that would treat everyone the same. And so he wrote this dissent that was so shocking to his colleagues that they came and privately urged him not to publish it. And in that dissent, Frankfurter began by saying, "Were my purely private opinion relevant to this case, I would certainly have decided it in favor of the witnesses, the Jehovah's Witnesses. Reflecting as it would be, a lifetime of commitment to civil liberties. And he also says, as a member of the most persecuted and vilified minority on earth, I am not unaware of what bias based on religion can do. This is Frankfurter writing this in the middle of the Second World War. So he's not kidding around when he says this. And then he makes this switch and he says, but as judges, we are neither Jew nor Catholic, nor are we Protestant nor agnostic. Our job is simply to interpret the Constitution. So it's a very elaborate rhetorical structure. What he's saying is, as a Jew, I would want to decide this case in favor of the oppressed minority. But I am not going to decide this case as a Jew. I'm going to decide this case as a justice of the Supreme Court, and as such, my duty is specifically to the Constitution. So he's disavowing, as a matter of the decision, the Jewishness that he is invoking. Now, his colleagues were upset because they didn't want him saying, as a Jew, in a Supreme Court opinion. It was the first time any justice had ever said as a whatever in a Supreme Court opinion. And after that, it took a long time for any justice to do that again. It's still relatively rare, though there were moments when it comes up. In the SFFA case, you had a version of that in an exchange between Justice Ketanji Brown Jackson and Justice Clarence Thomas about race. So it can come up. But at this time, it had never come up before. And as I say, the other justices were very worried about it. They didn't think it was appropriate, precisely because they all thought you should decide the cases. Of course, you decide the cases just as a justice. So why this elaborate performance of, as a Jew, I would do this, when your conclusion is going to be, I'm not doing it as a Jew? And the reason for Frankfurter is that ultimately the Constitution was for him his faith. And just to bring that home, in that formulation that I just almost exactly quoted, as judges, we are neither Jew nor Catholic, he was actually simultaneously paraphrasing Paul in one of the epistles, where Paul says, we are neither Jew nor Gentile, nor man nor woman, nor slave nor free, but all are one in Christ Jesus. So Frankfurter, who knew what he was doing, is the Jewish justice paraphrasing Paul, saying that in the new dispensation of Christianity, we don't have these divisions. And so Frankfurter is almost literally saying, under the Constitution, we don't have these divisions, which is the whole point of his holding, which is that the reason the witnesses shouldn't get an exemption is that would mean that people in the classroom would be treated differently, and he didn't want them to be treated differently. Now, leave aside that from today's perspective, it's hard to buy that as a punchline. That's the worldview that he had. Now, the reason that this is significant to the puzzle I'm talking about is that it sets a pattern, which is a tremendously appealing pattern for Jews who were generationally, as Frankfurter was, and as his students' generation, who became the first major generation of professors. In many cases, they were literally his students. He sent his law clerks and students out to become professors all over. The argument for that generation was tremendously appealing to think that they could, by being Americans, no longer be thought of and no longer think of their own practice as distinctively Jewish. They had made it. They were in America. They were in a liberal democracy. They were equal, so they could behave equally. Now, that's a tremendously appealing view. And as an aspiration, I share it. I think it's deeply beautiful. But notice that it involves, after the initial disavowal, it involves a displacement. It's the displacement of some idea of what the law with a capital L is from the traditional Jewish legal materials, Bible and the Oral Torah, to the American legal materials of the Constitution. So if you are willing to follow me that far and think that there is some disavowal followed by some displacement, then maybe we can begin to see what this generation of Jewish law professors was doing that made their activity Jewish. They were throwing themselves into the study of the law, of American law, as though it were the law with a capital L. Now that still leaves the final part of the puzzle, and I'll try to resolve this in the next couple minutes, and then I'll be quiet and take your questions and your objections. I hope will be copious. How? How could a generation of people who didn't have any training in the Talmud. You know, maybe they had had a bar mitzvah. How did that generation of people, and by the way, even had they wanted to get a sophisticated Talmudic education, you couldn't in almost any part of the United States up until the 60s or 70s. Tiny number of very small yeshivas, but overwhelmingly, the American Jewish community, upon arriving in the United States from Europe, were trying to create an opportunity for their kids to advance, and they didn't think those kids would advance if they put them in yeshiva. They wanted them to become doctors and lawyers and accountants and so forth. And so that wasn't the educational structure they initially created. So even if these folks wanted to, they mostly couldn't have gotten the kind of Talmudic education that later became available in the United States and that had always been available for an elite few smart people in Europe. Well, this is the hardest part of all because I'm going to have to fall back on the idea of a culture. And the idea of a culture here is that there are styles of language and styles of argument and styles of engagement that would have been found a generation or two before the generation I'm talking about in the Talmudic study house, but were never restricted to the study house, that made their way in to the daily rhetorical and discursive practices of almost all Jews from the Eastern European world. That may also be true for Jews from the Middle Eastern world, but that's not the topic of today's lecture. There are one or two Jews from that world who are law professors like this. Owen Fiss is a good example, but he's really the only one, pretty much, that I can think of in this category. And he grew up in the Bronx in a world that was, full of Eastern European Jews. His close friend in childhood was Mort Horowitz. Can't make this stuff up. So culture has the capacity to teach styles of thinking, styles of reasoning, and styles of argument that can then make their way through. And so last but not least, I would ask, can we look at the intellectual products of this generation of Jewish law professors and see anything there that resembles in structure the nature of Jewish legal study? And there is one, and I'll close on this hypothesis. If you look at the great American legal thinkers from the 1880s into the 1920s, the great majority of them were deeply focused on what you might call law as doctrine. Holmes, who is always an exception in everything, begins to break out of that because he's a legal historian as well, and he's prophesying the importance of economics and law, even though he's no kind of an economist. But he sees it coming. So Holmes is always the great exception. But the general thrust of the great scholarship of that era, and there's amazing scholarship from that era, is doctrinal and classical and formal. From the moment of the entrance in the post-World War II period of large numbers of Jews into legal academy, you begin to get philosophical, as in Ronald Dworkin, economic, as in Richard Posner, sociological, cultural, literary, and other disciplinary approaches making their way into legal thought. There are lots of reasons for that. The growth of the American Academy generally, the post-World War II era's interest in social sciences, lots of other bases. So I'm not making a reductive claim. But a noteworthy fact of the cultural style of Talmudic study is that it isn't all law. The Talmud is about 50% law. The other 50% is philosophy, theology, tales, stories, medical ideas. I mean, you name it. The Talmud says of itself, turn it over and turn it over because everything is in here. It's that kind of a book. And the Talmud is not an organized book. The Talmud is a complicated, discursive, kind of like random walk. If you read it, you have to reconstruct the logic of it. So I think it is possible, just possible, it's my hypothesis, that the one effect of the pervasive method, if you will, was the introduction into American legal thought of a mode of analysis that is unquestionably legal, that's still interested in the doctrine, but that wants to bring the doctrine back in every instance to some underlying set of ideas that can be philosophical, structural, societal, economic, sociological, literary, and even sometimes mystical. So if that's right, then there was some impact on American legal thought of the rise of Jewish legal education. If I were an empiricist, a quantitative empiricist, which I'm not, I would say, well, let's do an event study. Let's check in 50 years when there are many fewer Jews in the American Legal Academy and see how it looks. But I don't think this is the kind of thing that can be answered definitively that way. I think it's a matter of interpretation. What I'm describing is interpretation. And sure enough, that's Ronald Dworkin's famous idea that all the law is interpretation all the way down. And it would be hard to think of a more Talmudic or Jewish idea than that. Thank you very much for listening. And I'm really curious to hear your stuff.
So in my field, is it on? Which is health law and bioethics, like common territory. I think this is an easy case. The judge who makes the first pivotal move is Cardozo in 1914, where suddenly he rebukes the elite, non-Jewish physicians at New York Hospital by telling them that operating without the consent of Mrs. Schloendorf was an assault. The next big move, Jay Katz documents the silence that followed, where no one had the guts to pursue Cardozo's insights for 50 years. But the next big move is the trial of the Nazi physicians at Nuremberg and the announcement of the Nuremberg Code. So the rise then of health law and bioethics as a discipline is deeply imbued with the Holocaust and the torture of Jews and others in the name of medicine and science at the concentration camps. But the twist I would make and the challenge I would ask to your method here is that it seems to me in my field, the signature move that grows out of that, you see it first in Cardozo, then you see it in the judges at Nuremberg, and then you see it as things pick up steam with the law of informed consent, is precisely identifying with the most vulnerable, the most tortured, the one whose body is on the line, despite the fact that the elites are telling you, no, there's nothing to look at, we're doing it right. You know, the doctor,
The medical elites,
at New York Hospital. But the challenge I would make to your method is that as my field develops, it's not only Jews who are.
Of course not, yeah.
It's many others, and as you well know, on the wall in Owen's office are pictures of the fire hoses and a deep identification with the civil rights movement. And so the next judge to make a gigantic move is Spotswood Robinson in 1972. So I think there is something, I'm very interested, something distinctively about the Jewish experience and the sort of subject matter, the Holocaust that drives the development of this field. But it's not only Jewish. There are others who join forces and recognize the primacy of the person whose body, pain, and longevity are on the line. So I wonder if you think about this puzzle from the standpoint of maybe it's not only Jews who will take
it's not.
turn,
Yeah.
then it becomes a broader question. The Jews and the Jewish experience may bring something special, but then others from other experiences join forces.
Yeah. So first of all, thank you for a really sweeping and brilliant question. And I there are many parts of it. I'm going to try to take them all on board here. First, I think it is a really great example of where it might be possible to point to something Jewish there. I think there might be two subparts of that. One is the post-Holocaust concern for human suffering, which it's understandable that Jews would feel it especially strongly, but any other human who cares about the vulnerable would think of it in those terms as well. But there's another component, which is the Cardozo move, which is before the Holocaust by a full 30 years, which is to rely on the conception of consent in the framework of medical treatment. If the animating moral concern in medical ethics and bioethics and the law of bioethics is about concern for the oppression or the exploitation of the vulnerable, the conceptual move that is characteristic of the field, if I could speak in broad terms, is the one you mentioned, is the insistence that we have a solution, and the solution comes through the theory of consent. That's a very interesting thing because it's a conceptual legal solution to a very human problem of suffering. And I want to suggest, just because you suggested it, that there's something especially Talmudic about that. Right? You might say, well, what's the answer to the problem of oppression? Don't oppress people. What's the solution to the problem of torture? Don't torture them. To say, well, actually, there's a legal theory. And if we follow that legal theory, we'll conceptually solve that. The Talmud has, like, on every page, there's something like that. And that can be either really satisfying. It can give range, to use Cover's term, that's a jurisgenerative theory. It generates a lot of law. It's also subject to a withering critique, as we know from the whole school of thought that criticizes consent, the critique of consent, which runs across this whole field and across sexual ethics and a wide range of other areas. And it also has a lot to say, because it's pointing out, like, what do you mean a legal theory can solve, a legal framework can solve this? It can't. So first of all, just that's acknowledging, I think, a really fascinating juxtaposition there that you mentioned. Second, I couldn't agree with you more. None of the things I'm describing are all Jews. Very far from it. And a lot of these ideas, and if they're to be valuable, will continue no matter what. And so I don't think that it's, and obviously there were Jews on opposite sides of some of the most difficult and brutal fights in legal thought over the last 75 years. So it can't be that any one of their position was the Jewish position, and it can't be the Jews alone exemplify that. So I'm in total agreement with you there. Yeah, so thank you, really, really fascinating.
Don't be shy. Okay, would you like her first?
Hi, thank you. This is fascinating. I had never thought of it until I was sitting right here, but my 1L year at William Mitchell across the river in St. Paul, 2 of my 4 professors were Jewish. Never dawned on me before
Yeah,
that.
for a reason it should.
Yeah, interesting. So I just finished reading a book called Bad Jews by Emily Tamkin, who is also an attorney. And she talks about when Jews became white. And I wonder about Jews moving into professorships and the influence, or if you think there's no influence on that when Jews became white, maybe mid-century or a bit after.
Yeah, I think there's a lot to be said about this. So the first is that these events are closely connected, right? I mean, the reason that there were, one of the reasons that there was no Jewish law professors at Harvard, for example, before Frankfurt, and precious few anywhere else, is that there weren't very many Jews in the United States. Another reason is there was anti-Semitism. In the post-war period, Jews were taking advantage of a movement that started with the Anti-Defamation League and others, in the early 20th century at the time of the Leo Frank lynching, with a self-conscious effort to convince the world that Jews were white. And then beyond that, to suggest that Jews were not a race at all. I mean, the way that Jews became white is a little different than the way, say, the Irish became white some short period of time before that. That was by saying the Celts aren't a separate race. The Jews were part of the movement to say that, that they're not a race at all. And that was successful. It's, by the way, got a fascinating doctrinal side today. I mean, I was involved in a 3-hour conversation with colleagues recently. It was an all over the place conversation. I won't give you the details of it, but it was about the following question. Title VI of the Civil Rights Laws, which governs educational institutions, the law that's being invoked now by the Trump administration in demanding various changes from universities on the grounds of anti-Semitism. That's the failure to protect against anti-Semitism. Title VI doesn't mention religion. It says race or national origin discrimination is outlawed. And that was by design because they didn't want the Title VI law to say that a religious school was unlawful, because a religious school could, like a Catholic school could have said, we want to only have Catholics. So they didn't want to, so they left it out on purpose. So now there's a doctrinal question of, does Title VI apply to Jews at all? And to answer that question, you have to get into the question of what are the Jews? And so I sat there in my lunchroom, describing to colleagues older and younger than I am, who were Jewish and never thought about this before in any way, shape, or form. Well, it's really complicated because Jews were thought of as a race And if you go to 1964, that was at the moment when Jews were starting to say, we made it, we're not a race anymore. We succeeded. So there's a whole complicated story to be told there. That movement was part of the movement of the entrance of Jews into elite American life. And unquestionably, that's a big part of this story. Unquestionably, it's a big part of the story. When it comes to race, however, that generation of Jews were mostly, not exclusively, strongly identified with the civil rights movement. They cared about the civil rights movement, they engaged in the civil rights movement. And this is the basis for a huge and ongoing debate between blacks and Jews about, to oversimplify a little bit, whether Jews did that because of a universalistic response to their own experience of oppression, or as part of an opportunistic political movement to produce social equality, which, if it never really included black people, would at least get them over the hump. And like every such debate, it's oversimplified, and there might be a little bit of truth to both, and it can never account for individuals, many of whom will have been motivated entirely by desirable, and worthy of emulation beliefs. But that's part of that story as well, for sure. I will say it's noteworthy that it took a long time for a meaningful number of African Americans to come to the American Legal Academy. And our collective law professor numbers are still not that great relative to the national average when it comes to race. So it's just an indication that entrance into these institutions was subtle. I would also add, last but not least, that the generation of Jewish law professors who became professors in the 50s and 60s had the interesting, and even into the early 70s, had a really interesting feature that hasn't been true of law professors since, which is those folks, many of them were like, wherever they went to law school, they were first in their class, they were president of the law review, then they were put on the faculty. Many of those people could not have gotten jobs at the top firms, which were still called white shoe firms. And white is not race in that context. The phrase white shoe goes back to a fashion that East Coast boarding school boys wore white bucks, all white buck shoes, all year round. So they came to be called white shoe, or shoe for short. And so those were the kind of people who went to those law firms. God knows no one who wore white bucks to their law firm. Obviously you wear polished brogues or town shoes, but that term attached to capture the old East Coast establishment. And those professors were able to become professors at East Coast establishment universities at a moment when they might not have been able to become partners at the firms. And then that passed away with time. Basically that changed over the 70s and into the 80s, which there's a literature on as well.
Working. Thank you. That was really great. Hi. I was thinking in particular about a subcategory of American professors who are my own field's professors. I'm thinking of international lawyers, and my sample is not a broad sample. It's two particular people I knew: Lou Henkin, who was my mentor, and Oscar Schachter, who was still alive, not teaching, but certainly very articulate in his 80s at Columbia. And I'm struck by the ways in which a particular group of American Jews who were international lawyers in the period you're describing were enormously influential, and in very particular ways, in this kind of way that Philippe Sands talks about Hersch Lauterpacht being enormously influential. And so I wondered, I'd invite you to reflect on that, but also to think about how the sort of point Susan made about a particular kind of universalism, which is embodied in the Holocaust experience. And Lou was the son of a rabbi who had been, in fact, he had some yeshiva training and was observant to his very last day. Yes. And so I think there's something quite interesting about the way in which, and Oscar wasn't observant, but was very certainly both culturally and multiply defined as Jewish. So I wonder how that subgroup of maybe two or more fit in your story.
Great. That's a great and very important issue to raise. So first, just a biographical note about Henkin. You're absolutely right that he was, when I said there were maybe only one or two who had Talmudic training, he was the person I had in mind. And it just to show you that if that was known about him, in the circle of Frankfurter clerks, he clerked for Frankfurter, he was known to everybody, including Frankfurter, as the one person who was Jewishly knowledgeable, which Frankfurter acknowledged by asking him to say the Kaddish memorial prayer at Frankfurter's memorial service, which was the only acknowledgement at all in Frankfurter's life after he was 19 that he was Jewish. And this memorial service it wasn't just your average everyday memorial service. It was designed by Frankfurter to mimic Brandeis's memorial service. The same poem or passage from Pilgrim's Progress, very carefully chosen, a very not Jewish poem, was read to transfer the sword of authority, that's the line in the poem, but that's the reference in the poem, to the next generation. And so this was this incredibly elaborately staged event at which all of the former clerks and others were there. And they were all professors at law schools, for the most, tons of them were. And so Henkin was singled out in this way to play the role of the son. Frankfurter was childless. It was specifically because of his Jewish identity. So they knew this about him, and they, at some level acknowledged it in that moment. The deeper part of your question goes to the issue of whether there's some natural connection between being Jewish and being a universalist. And that's a vexed and complex question. There is a well-known strand of post-emancipation Jewish thought, and emancipation is used to refer to the moment when Jews in Europe were permitted to own property and to become citizens and ultimately to participate in political life, which happened at different times in different places, but basically took place in most of Western Europe between Napoleon and the later part of the 19th century, over that long century. There is a familiar trope of Jews in that era calling for universal rights. And you could think of the Fists and Ackerman commitment to civil rights as a similar version. It's a universalist picture of an appeal to rights. And again, the idealistic way to describe that is to think of it as Jews aware of their own experience, universalizing, in a sort of biblically inspired way. Thou shalt love the stranger, for you were strangers in the land of Egypt. That's a universalizing move. And then the more cynical, political, analytic view would be to say, well, Jews were an oppressed minority, and universalization might have the effect of freeing them from that. And so naturally, it was very appealing. There's also a complexity of this trope because there's also an anti-Semitic trope that accuses Jews of being universalists and therefore cosmopolitan and therefore not rooted and committed to their countries, which of course, like all anti-Semitic tropes, has a nested opposite that says the exact opposite at the same time, which is that Jews are distinctively and uniquely only interested in other Jews and are therefore the most clannish of people. So that's the same way that Jews could be the ultimate capitalists and simultaneously the ultimate communists. And then in, the kind of like Henry Ford Protocols of the Elders of Zion view, it's true that Jews are capitalists and it's true that Jews are communists, and it's true those things don't go together, but secretly they're all on the same side. That's how a conspiracy theory, squares the circle. In this instance, it's the universalism accusation and the simultaneous clannishness accusation, which aren't inherently themselves reconcilable. Do I think that there's a familiar and identifiable strand of universalism among Jews in the legal academy? I do. I absolutely think it is possible to identify that. And international law in particular, it makes sense that one would see some version of that. I would just note that it didn't always go that way. And Hannah Arendt, not a law professor, is a really interesting example of this view. That begins with the idea that there should be universal rights, but then if you say you can't get those universal rights except through a state, then the real problem is statelessness and you need a state. And so then it becomes about particular actual concrete rights given by a state rather than more general guarantees given by international law. A kind of sovereigntist vision emerging from the same impulse to protect everybody. But yeah, I think on the whole that correlation can reasonably be made. Yes. Did we lose our...
With Bill gone. Oh,
yeah.
the microphone.
All right.
Just the all-encompassing importance of identity to the various critical studies movements sort of make the case that the denial of the importance of Jewishness is actually a feature of Jewish legal education?
Well, can you hum a few more bars of that?
The last question, just so you know. So wrap it up beautifully.
Okay, I'll wrap it up. I'll try to wrap it up beautifully. I mean, can you just say one more sentence about why you think that would be the case?
Because
Because there were Jews on both sides of that, right? There were
but
there were Jews in the CLS movement, and then they were killing their fathers, who were Jews, who were shocked and horrified because they saw a challenge to their universalism, among other things.
but you notice that they didn't do it as to their Jewishness. They did it as to race, they did it as to gender, but you don't find a critical Jewish legal study.
That's true. There is no such
And
genre
that-
as critical
that is
Jewish
the
legal studies.
The point
Yeah.
is that even in participating in this identity focus movement, they
Yeah,
hide
so
or
I like that. I'll take that as a friendly and plausible argument. What it would suggest is that on both sides, there was an impulse to disavowal. In the CLS movement, no one says, well, this is identity for identity's sake. The idea is to encourage acknowledgement of the identity of the oppressed for liberatory purposes. And that's not all CLS. Some of that is also the critical race studies movement that comes out of CLS and is different from it for that reason. But it's meant to be for liberatory purposes. And therefore, there is something of denial of the particular experience if you're out of the oppression, if you don't feel oppressed anymore. You could approach that. And then on the other side, among the opponents of CLS, both among the law and economics people, and more importantly, among the sort of classically liberal professors and deans of the Frankfurter generation, who were the direct targets, or I don't know if they were, they experienced themselves as the targets of CLS and were deeply anguished about it. For them too, they might have seen, among other things, the particularity and the refusal of universalism as threats to the very commitment they had to disavowing anything specific about them. Because they're not just disavowing being Jewish, they want to disavow all specificity in the service of something, to go back to Fanilla's point, more universal in its content, the rule of law as a universal ideal. So I don't want you to go home and say Feldman said that the rule of law as a universal ideal is a Jewish idea that came from the Talmud. I'm not saying that. I do think one can tell a story in which that approach can be found in biblical and Talmudic sources, but the Talmud is full of some of the most intense particularisms you could ever imagine. And Jewish thought, especially medieval Jewish thought, up to the early modern period, less so in the modern era, is chock full of that, which is not so surprising if you're looking at an oppressed minority. Oppressed minorities feel like they have to stick together. And in that sense, they're very identitarian. As identity, so identitarian that they would make critical race studies seem universalistic in comparison. So I think I don't want to argue for a universal presence of universalism there. But I do think that for the generation that I'm talking about, there was something meaningfully Jewish about the way they engaged with the law and the way they engaged with legal thought. And I think that is a contribution. And like all contributions, and since the Rubenstein lecture asked us to think about contributions, like all contributions, doesn't go without saying that every part of that contribution is true, or that every part of that contribution is desirable, or that every part of that contribution is good, or that you can point to the contribution and say those are the bad things. Contributions are just what they are. They're contributions, they're meaningful, and then they are an introduction to further debate and discussion. Thank you very much for being such a